Good morning, students. Today we are going to learn a topic that is known as members of a company. Members of a company are those people who owns the shares of a company, right? And who has their name recorded as the equity shareholders or as the shareholders in any company. Basically, members and shareholders, these two words are used interchangeably, but there is a slight difference between a shareholder and a member. The shareholders are the owners of a company who invest in a company, who purchase the shares of a company. But a member of a company, there are two basically conditions. The first condition is when we have to become a member of a company, we have to own the shares of a company, right? And our name should be in the register of members of a company, right? And the second condition is when you own the shares of a company, in that situation your name should be as the beneficial owner in the depositories. Now let us elaborate these 2 points and let us study in detail these 2 points. What are these 2 points? Now, as we can see, the two basic criteria to become a member of a company is, first you have to register your name in the register of members of any joint stock company in which you own the shares. Now, what is register of members? Register of member is a type of a recorded document in which every fine detail of a member is recorded. When the purchase has been done of the shares, when the member joined the company, on which date his details were recorded, his occupation, which city he belongs, nationality, amount of shares he has purchased, his address, his registration number. So everything related to a member is being mentioned in the register of members. As soon as the person joins the company, his details are being recorded in the register of members, and as soon as the person leaves the company, his details are being removed from the register. And the second most important condition to become a member of a company is you have to own the shares of that company, and your name should be in the depositories as the beneficial owner. Now, what do you mean by beneficial owner? Beneficial owner means an investor who owns some of the securities in any of the depositories in electronic form. Right? Now, what is depository? Depositories are type of institutions, are type of an administrative institutions that owns the securities in electronic form, right? In electronic form means in dematerialized form. That means the securities or the documents or the certificates of any securities that you own, they are not in physical form or paper form. They are electronically recorded in one of the depositories. In any depositories, when you store your securities, and that depository has your record as the beneficial owner of some of the securities, that person will be the owner, that person will be the beneficial owner of that depository, and that is the second condition to be a member of a company. Now, let us study the depository. Depositories are the institutions holding securities and financial instruments in an electronic form. Securities can be shares, debentures, bonds, derivatives. These are all the depositories. So, when a person holds the shares of a company, so he can deposit or he can store his shares or share certificate. Like, share is not something which we can touch or we can feel or we can store, right? it is something which you own, right? So a share is a form of a, is a part of a ownership that you own in a company, and in that situation we get the share certificate from the company, which is a type of a proof that you own some of the shares in that company. So in that situation, if you hold some of your securities in any of the depositories, that means you become the owner of the depositories. The depositories work is to store your securities in electronic form, and that is known as dematerialized form. Now, a shareholder has to open a demat account in any of the banks, and then he can operate it through the depositories. He can personally also approach the depositories to open an account through the depository participants. Depository participants are the type of the brokers that deals between the persons who wants to keep his securities in the depository and between the depositories. So it acts as the mediators. There are two depositories in India, NSDL and CDSL. NSDL is National Depository Securities Limited, and CDSL is Central Depository Securities Limited. So overall it is also a type of a bank. In a bank you keep your deposit your money, but in depository you keep or you deposit your securities in an dematerialized form, and whenever you want it back you can take it in a rematerialized form, that is known as physical form, that is in the form of a certificate. Hello students, today we are going to see a topic that is known as eligibility of membership. As we have already studied what is a member, right, and under what circumstances or under what situations can that person be a member without being a shareholder, or a shareholder without being a member. So let us see the eligibility of membership, that is to become a member. Who are the persons that are eligible to become a member, or who are the institutions, what are the institutions that are being eligible to become a member in a company? Now, the eligibility of membership is divided or broadly classified into the individuals and the organizations. Now, individuals, there are many people, there are many sort of members of different types of organizations or individuals from various forms of business organizations that are being categorized under this classification of individuals. The first one is minor. Minor means an individual who is under the age of 18. That means he is not legally competent to enter into any legal contract of any company of any law, right? So in that situation, a person who is a major and who on behalf of a minor can purchase the shares, can purchase can come into the contract on behalf of a minor, but a minor himself cannot be the member of any company, as he is not having the perfect age to be into the legal contract of any company. That means he cannot do any of the contracts legally, he cannot purchase the shares of a company, and ultimately he will not be the member of a company. So if the minor is having some of his family members or his father, friends, some of his known person as his nominee, so that person on behalf of a minor can purchase the shares, but the minor himself cannot be a member of a company. The second is insolvent person. As we have seen, insolvency means to be bankrupt or declared insolvent by bankrupt by the banks, by the law. In that case, the insolvent person is not capable of purchasing the shares, of being the shareholder of a company, becoming the member of a company. So in this case, the shares of the insolvent person are transferred to its official receiver. The official receiver takes care of the shares of that person. So in this case, the insolvent person is himself not eligible to become a member of the company. That means, as he was the member of a company earlier, so after transferring the shares, after becoming insolvent, he has to remove the name of himself from the register of the members, and he cannot be legally competent to become a member of a company. The third is lunatic person or insane person. A person who is mentally not capable of entering into any of the contract. In that situation, the person is not capable of being the member of a company, and the company law or any other law denies the membership of the lunatic person in any of the companies. So ultimately, the person cannot continue to be the member of a company, and his legal representative owns the shares, or the shares are transferred to his legal representative. The next is foreigner. Any foreigner can invest into our Indian companies. There is an act that is known as FEMA Act, FEMA 1999 Act, right? It is Foreign Exchange Management Act. It is this act is totally based on the foreign exchange activities, internal external trading. So whenever an outside company, outside foreigner person wants to invest in our country or in our Indian companies, in that case he has to read all the provisions, he has to follow all the rules mentioned in the FEMA Act, and then only he can become the member of a company. So yes, the foreigner can become a member of a company unless and until according to the provisions of FEMA Act 1999, right? Now the next is Karta. Karta is a senior most member of Hindu undivided family business firm, right? So the Karta himself can become a member of a company. He on his own name can purchase the shares of a company and can become the member of a company. Similarly, the partners of a partnership firm are legally liable to enter into the contract with the company and become the member of a company. Now, let us categorize another form that is known as organizations. Organizations are categorized into various forms of business forms. The first one is company. Company means joint stock company. As the joint stock company is a registered firm, it is an incorporated association. That means the company has its own legal entity. So definitely anybody having its own name registered, having its birth certificate in the form of incorporation certificate, having its legal entity, so that person, that company, that artificial person is legally liable to become a member of a company. So a company itself can invest into the shares of another company and can become the member. The second is cooperative society. As the cooperative society is also a registered firm, it is registered under Indian Cooperative Societies Act. So in that case, it is also a registered firm, and similarly in any cooperative societies can also be a member in any of the companies. So it can invest into the any joint stock company, it can invest into any another cooperative society and can become a member of that company respectively. Then next is LLP. LLP is limited liability partnership. Limited liability partnership is a form of a partnership firm which is having some of the features of joint stock company and some of the features of partnership firm, making it competent and competitive in this business platform. Now, LLP, as it is a registered firm, because joint stock company is an registered firm, so it takes one of the features from that joint stock company and becomes the registered firm. So again, LLP is also competent to become the member of any of the joint stock company. That is, an LLP is legally liable to become the member of a company in its own name, apart from the partners. The next is HUF, that is Hindu Undivided Family. Hindu Undivided Family is a form of a business organization again, but it is not compulsory to register this form of business form. It is only compulsory in Maharashtra. So in other states, it is not legally competent to enter into the contract and to become the member of a company, as it is not a registered firm. As it is not a registered firm, it do not have its own identity, and ultimately it cannot become the member of any of the company. But the karta of the Hindu Undivided Family firm can definitely become the member of the company, as we have seen earlier. The next is partnership firm. Partnership firm is a form of a firm where two or more partners come together and form a partnership firm and do all the business activities. In that case, the partnership firm also, there is no need to register the partnership firm, just an agreement will work. The partners have to make an agreement which is known as partnership deed, and with the help of that deed they can divide the profit and losses between them. So there is no such compulsory provision to register any partnership firm. So in that case, again, the partnership firm is not eligible to become the member in any of the company, but the partners themselves on their own name, apart from the own identity of partnership firm, the partners on their own name can become the member in any of the company. And the last one is trust. Any registered trust can become the member of any of the company. Trusts are again, they work like NGOs, non-profit associations, non-profit organizations. So these trusts, if they are registered, they can definitely invest in any of the company and use that amount as in the welfare of the people. So definitely a firm that is registered can become member in any of the company. Now let us summarize this. First, individuals. The minor himself is not eligible to become member. The insolvent is not eligible to become a member. Lunatic not eligible to become a member. But Karta, yes, Karta, apart from his HUF, can become the member in any of the company. Next is partners. Yes, partners on their own name, apart from the identity of partnership firm, can become the member in a company. Then foreigner. Yes, foreigner can also become if it is mentioned in FEMA Act 1999. Then the company. Yes, company is eligible, as the company is the registered firm. Now cooperative society, yes, it is also eligible to become member of a company. Next is LLP. Yes, it is also eligible because it is also a registered company. Next is partnership. Next is HUF. No, HUF is not eligible because it is not compulsory to register HUF, and same goes with partnership firm. There is no need to register partnership firm and just a deed will work. So in that case, a partnership firm also cannot become a member in a company, and any registered trust can become a member of a company and can invest in any of the company. Hello students, today we are going to start a topic that is known as acquisition of membership and termination of a membership. Acquisition of a membership means when a member, in what manner, under what circumstances, under what conditions he can become the member of a company. If you want to become a member of a company, what are the circumstances, what are the conditions, what are the ways in which you can become the member of a company. Earlier we have studied members versus shareholders. That is, when you have to become a member of a company, under what circumstances, and under what circumstances you are becoming the shareholder of a company. And when you are becoming the member, you are not the shareholder, and when you are becoming the shareholder, you are not the member. So today, now let us start with the acquisition of membership. The first one is by subscribing to the memorandum. As we have seen it earlier, by signing on the memorandum of association, because the memorandum of association is the most important document. It is the charter of the company. So when you are signing that document, when you are approving that document, or when you are subscribing for it, under that condition you become the member of a company. So in a public company, minimum 7 members should be there who are signing the memorandum of association. In a private company, minimum 2 members should be there, and in a one person company, 1 member should be there to become the member of a company, and these people are the first members of that particular respective companies. So by signing the memorandum of association, we can become the member of that company. The second is by application and allotment. This is a very basic process where you apply to the company by seeing their shares on any share market. Once you are satisfied with all of the rules, all of the provisions of that company, so you can start investing in it. Then you need to apply for it. You need to purchase the prospectus, and then you need to apply for the shares. That is by filling the application form. Then by seeing the requirements, the company allots the shares to the shareholders, and after that the person can become the shareholder, that is the owner of the company. And after that, after becoming the shareholder, the person's name is entered or is registered in the register of members, and ultimately he will become the member of a company. So this is the very basic criteria. When a person becomes the member of a company, you need to apply for the shares, the company allots the shares to you, and after that you become the shareholder of a company, and ultimately you become the member of a company. So these are the two ways in which you can become the member of a company, which are very basic, uh, conditions. The next is by holding shares in dematerialized form. Once you hold the shares, once you own the shares of any of joint stock company, you can deposit, or you can keep it that in any of the depository. Once you enter your name in any of the depository, then you become the beneficial owner of that depository, and ultimately this is one of the basic requirement to become the member of a company. So if you own the shares of that company, you become the beneficial owner of any of the depositories, because you have kept your securities in dematerialized form in those depositories, right? So any of the depositories, you can keep your securities, and then you can store it over there, and then the depository records your name as the beneficial owner, and this is the foremost condition to become a member of a company. The next is by transferring of shares. Once you transfer your shares to another person, right, so that another person becomes the shareholder, because he is purchasing the shares from the existing shareholder of that company. So once a person buys the shares from the existing shareholder of a company, he gets the shares of that member, and ultimately he becomes the owner, that is the shareholder of that company. And again he can put his name in the register of members by approaching to the company, and then he can again become the member. So these are the next two conditions where you can become the member of the company. The next is by transmission of shares. we have seen earlier, transfer of shares is when you transfer your shares by your will, right, to anyone whom you know or whom you want to transfer. Transmission of shares is under some circumstances or under some situations you have to transfer the shares with the help of law. So in the extreme conditions, like when the person is dead, when the person has become insolvent, when the person has become insane or lunatic, under these conditions you need to transfer the shares. This is known as transmission of shares, where you are forcefully passing on the shares or transferring the shares to another person, right, but not by not your will, but under some urgent and extreme conditions you are transferring the shares. So in case of death, the legal representative or the legal heir of that person is responsible to take care of the shares. In case of insolvency, the official receiver, which is appointed by the court, that person takes care of the shares of the insolvent person. And in case of insanity of a member, the administrator, the legal administrator is appointed and he takes care of that shares. So in the process of transmission of shares, the legal representative or the heir, the official receiver and the legal administrator, these people take care of the shares, and ultimately they are the shareholder and they can become the member of a company. The next is nominee of one person company. As we have seen, one person company is run by a single person, right? It is a registered, it is an upgraded form of a sole trading concern, right, with some of the features of sole trading concern and joint stock company. So one person company is having only one member, but the company cannot depend upon the one member. If the one member um, faces with any of the extreme conditions in life, like insanity, insolvency, death, so in that situation he should have someone behind to look for his business, and that person is known as nominee. So the person appoints the nominee already when he is registering for the company, and the name of the nominee should be mentioned in the memorandum of association of that one person company. So as the one person in OPC is the sole owner, after his death or after his insanity or after his insolvency, the nominee of the person takes care of the shares and the company, and ultimately he will become the sole owner and the shareholder or the investor in that company, and he can become the member in that company. The last is by acquiescence or estoppel. We have learned this principle of estoppel earlier, or acquiescence. What do you understand by the principle of estoppel? Principle of estoppel means when a person intentionally or unintentionally has let his name on the register of members in a particular company in which he holds the shares. That situation is known as principle of estoppel. Means the person is no more shareholder of the company, because maybe he has transferred the shares, he has left the company, he has returned the shares which he holds to the company, but he has forgot to remove his name from the register of members, and he has forgot to remind the company about not being his member. Under that circumstances, the company will definitely consider him as a member, and he will be continued as the member. So all the liabilities, all the um, uh, things that are being done and managed by a member, that person will also be responsible for all the liabilities, for all the duties, for all the rights which existing member is getting. In case of a liability, that particular member cannot deny that I am not the member of that company. He has to take the responsibility of all of his liabilities. So as we can see in the PPT, principle of estoppel, when a person has wrongly entered his name in the register of members, when the person is not getting rectified whether he is the member or not, or he has to continue his name in the register of members or not, whether the member knowingly allows his name to remain, right, because he has forgot, or he has knowingly he is just allowing his name to remain in the register of members and not informing the company about the mistake. So these are the conditions which is responsible for the principle of estoppel. Whether knowingly, whether unknowingly, the person is keeping his name as a record in the register of member of a company, so ultimately he will be the member of the company until and unless he remove his name from that register of members. Now let us start with the termination of membership. Under what circumstances the member is not the member of the company, or the member is not getting the benefits, the responsibilities of a member. That means what is the termination of any membership, when under what circumstances a member is stopped denying his benefits as the members. The first one is buyback offer. Buyback offer means when a company is buying back its shares from their existing shareholders in the market rate or the rate above the market rate, right? In some circumstances, company needs to improve the company needs to develop itself, so or company needs to manage his shares and finances in such a condition that it will bring efficiency in the company. So under many situations the company needs back its shares, or when a person when people are not interested to continue with the company, under that circumstances, instead of passing on the shares to some other person, the company buys back the shares from its existing shareholders. That means the company takes back its shares from the shareholders. So that policy is known as buyback offer. So when a company buys back shares from the existing shareholders, that means the person is not the shareholder because he has gave back his share to the company itself. So the person is not the shareholder and ultimately he will not be the member. The second is transfer of shares. Once a person transfer his shares to another person, he will not be continued as a member of a company. The person whom he is transferring the shares, that is the transferee. So that person is can be a member because he owns the shares, but the person who transfer the shares, that is the transferor, he is not the shareholder of a company. Ultimately he will not be the member of the company. The next is death and insolvency. On the death and insolvency of any of the member, the membership of that person ultimately stops because the person is dead. So definitely he will not be the member, and if the person is insolvent, the government, the bank, the company will never allow him to continue as a member. So definitely under these two extreme conditions, the person can never continue as a member. The next is lien over the shares. This means lien over the share means the member is not allowed to transfer his shares until and unless he has paid the amount of the shares held by him. For example, if I own rupees 5,000 shares in a company, and if I have paid rupees 4,000 and 1,000 rupees is balance, right? But if I want to, within that period, if I want to transfer my shares, so company will not allow me to transfer my shares. Why? Because I have not paid the whole amount of which shares I have taken. So this is known as lien over the shares, where a member is not allowed to transfer his shares without the permission of the company until and unless he pays all the money, all the amount of which shares he has taken. The next is forfeiture of shares. Forfeiture of share means cancellation of shares, right? Why? Because the shareholder or the member has not paid the amount of which the shares are held by him, right? So if I have not paid the amount of the shares held by me, for example 10,000 rupees shares I have taken from any company. So if I have not paid the amount, the full amount or the half amount, or I have not completed my 10,000 amount, in that situation the company will cancel my shares. The company does not cancel the ownership of the share immediately. The company calls for the amount in installments, right? So company gives you one or two warnings, and until that date, the date given by the company, you are not able to pay that amount of the shares held by you. So in that condition the company cancels your shares, and this is known as forfeiture of shares. And the amount, if you have paid some of the amount earlier, that amount is again not refundable. That means you do not own the shares in that company, and some of your amount which you have paid earlier is also not profitable to you, and it is not refunded to you. The next is surrender of shares. Surrender of share means a person voluntarily on his by his own will surrenders the shares to the company. Why? Because again he is unable to pay that amount to the company. Why? Because a member, because of any of his personal reason or personal situation, he is unable to pay the amount of the shares held by him. So he himself by his will surrenders his shares to the company, that he is not able to continue with the payments in the long run. So the company takes back his shares, and again if he is not holding the shares, that means he is not the member of that company. The next is redeemed shares. Redeemed shares means redeemable preference shares, right? So basically broadly classification, if we are doing of the shares, there is equity shares and preference shares, right? Equity shares are those shares which we are studying till now, that the share capital of a company is divided into small indivisible units, and the one each of the unit is known as a share, right? For example, if your share capital is rupees 1 lakh, so 1 lakh will be divided into rupees 10 each share. That means the company has rupees 10,000 shares of rupees 10 each. This is the equity share capital. Preference shares means these people do not have to um, take the profits in the ratio as per the profit and loss earned by the company. Equity shareholders earn the profit or the dividend in the form of the profit and loss. If the company is earning so much of profits, in that situation equity shareholders earns much of the money. But if the if the company is suffering some loss or is not earning that much of profit, so it will the dividend of the equity shareholders will depend accordingly. But the preference shareholders, every month they will get a same amount of dividend. So preference shares is for that people who do not want to take risk, because their dividend should not be dependent upon the profit and loss of the company. That is why they do not invest in the equity shares. Equity shareholders are the risk bearers. They take the risk of their dividend depending upon the company's profit and loss. तो कंपनी को बहुत ज्यादा लॉस होता है तो इक्विटी शेयर होल्डर्स एंजॉय दैट मनी. कंपनी को लॉस होता है या कंपनी को बहुत ज्यादा स्टेबल प्रॉफिट होता है, इन दैट केस और इन अंडर दैट circumstance or under that period, the equity shareholders do not enjoy the profit, but at the time of profit they enjoy much of the money, so it is compensated. But preference shareholders are those people who do not want to take any of the risk. They want equal money every month, so that is the preference shareholders. Now, preference shareholders are divided into two broad categories: redeemable preference shares and irredeemable preference shares. Redeemable preference shares are those preference shares which are taken for a certain time period. For example, 2 years, for example, 5 years. Irredeemable preference shares are taken for lifetime of the company till the company gets wind up. Right? So, redeemable share means if I have taken purchased the redeemable preference shares from a company, for example, for 5 years. So after 5 years, right, I will be returned my shares to myself. That means I have to return the shares to the company. That means I am no longer the shareholder of a company, and if I am no longer the shareholder of a company, ultimately I will not be the member of that company. So redeemable shares are those type of shares which is returned or which is redeemed after a fixed time period of time, and after that period of time the member do not continues as the shareholder, as the owner in that company, right? And irredeemable preference shares, the shareholders will get the ownership, matlab they have to return the shares to the company after the winding up of company. So irredeemable are a type of a long term shares, and redeemable are for a fixed period of time. The next is misrepresentation of information in the prospectus. Now, what do you mean by prospectus? Prospectus is anything, any document of an institution in which you get a detailed information about that institution. When was it formed, how is it working, who are the authorities in that institution, which product, which service that institution is providing, the formation date and everything. If any information in the prospectus is written wrong, misrepresented, or frauds, that a frauds is being identified, so under that situation the member can definitely claim the company that because of your misrepresentation, because of your fraud, because of your fault in your prospectus, I do not want to continue as a member in your company, right? Because some of the policies or some of the things that are written, that are mentioned in the prospectus, an investor sees that policies or something, and it gets and he or she gets attracted towards the company. But later on, after the investment, if you find out that those policies through which you get attracted towards the company, those are false, right? Those are not correct. So in that situation, definitely this is the a very big mistake from the company, and the company is responsible for the frauds. And under this circumstances, the member can deny his membership. He has whole right to deny his membership, and under this situation the member cannot be a member. That means he discontinues to be a member of that company. And the last is winding up of the company. That means when the company closes, when the company wind ups, when the company shuts down following a legal procedure, in that condition also the people who have invested do not continue as a member. That means their membership is ceased or the membership is terminated.